My lords, before I come on to my next point, may I just go back to a point raised by my Lord Justice Lewis, and that relates to the recast directive 2006-54 that Lord Justice Lewis gave to me yesterday, and I've had the opportunity to reflect on overnight. The important point in my submission is that while it continues to draw a distinction between state social security schemes, if I can summarise it in those terms, and occupational social security schemes, it makes clear that occupational social security schemes can include injury benefits. And the importance of that in particular, my lord, is if one looks at the enabling power, the treaty provision that allows for the making of the directive, we can see it's Article 141. So in other words, the Council concluded Article 141, ex Article 119, now Article 157, was wide enough to embrace occupational schemes, including those providing for injury benefits.
Yes, for those of us not as steeped as you and me in the history, it goes Article 119, Article 141, Article 157.
Yes.
They're all essentially the same.
Yeah, they are.
So really you had already jumped on Lord Justice Lewis's bandwagon, but you're now explaining a little bit more fully.
Precisely.
Why. Yeah, that's fine.
Just, I'm putting an argument rather than just saying yes, please. As to the impact of Brexit and the route that we take through the relevant statutory provisions, just to draw your attention to something no doubt you've picked up already, but Ms Clark issued proceedings pre-IP Day, and just for your note, that's page 207 of the hearing bundle. Ms Bell issued post-IP Day. Can
you just give us the date for Ms Clark's issue?
Certainly. Ms Clark was the 4th of November 20.
Yeah.
Page 207.
Yeah.
Ms Bell was 21st of January 21.
Yeah.
So 3 weeks.
Yeah.
Late. As to Ms Clark, who is the easiest, may I just follow the route through? Can I ask you please to turn up tab 49, volume 1, and that is page 530. We see this is the main saving provision, so all rights, powers, liabilities and so on under section 2.1 are preserved.
Where are you now?
Sorry, I beg your pardon. Section 4, page 530.
Yep.
Sorry, I should have given the correct page number, I beg your pardon. So they're all preserved, so provisions made under section 2.1, obligations arising and so on.
Sorry, wait a moment. Section 4, aren't you?
Yes.
Oh, I see. Sorry, that's the title. Yeah, thank you.
So section 4, all rights, powers, liabilities, obligations, restrictions, remedies and procedures, which immediately before exit day are recognised, are enforced and allowed. So she relies on that. We then turn to the exceptions to that, which we see at section 5. And we see 5.1, the principle of supremacy of EU law does not apply to any enactment or rule of law passed or made after IP completion day. Well, we're not concerned with that. 2, accordingly, the principle of supremacy of EU law continues to apply on or after IP completion day so far as it's relevant to interpretation and so on. So one can have on or after both in relation to rules and interpretation so far as relevant to the interpretation or disapplication or quashing of any enactment. So just following it through then, accordingly, the principle of the supremacy of York continues to apply on or after IP so far as relevant to the interpretation, disapplication of any enactment, rule of law passed or made before the completion date. We have, however, subsection 4. The Charter doesn't apply.
We're not worried about the Charter, are we?
Well, I'm going to ask you to look at 5,
Oh, I see, okay.
because subsection 4, that being the Charter, does not affect the retention in domestic law in accordance with this Act of any fundamental right or principle which exists irrespective of the Charter. So we have the fundamental principle of equality, the general principle of equality, which we say is applicable, the Mangold principle, as we've referred to it in our skeleton. So we have the general principle of equal treatment. It's reflected in the Charter, but it's a freestanding general principle.
Sorry, fundamental principle of equality, but what equality are you referring to?
The general principle of equality, which informs, which is directly effective. So, for example,
okay, sorry. Well, then it's the general principle of effectiveness you're relying on, isn't it?
no, it's the general principle that the legal obligation arising out of EU law that any general principle is directly applicable. So, without the need to have any transposing legislation. So, Mangold, as you'll recall, was an age discrimination case, sought to rely on the Directive 2078, protecting against age discrimination.
I'm sorry.
May
I
just
thought you were
finish
putting
this?
all right. I thought you were putting your case on leasing, not on direct effect.
We're putting it on leasing, but we have to. What I'm trying to track through is how this falls within the scope of EU law at all. So we get to the interpretation provision. The interpretation provision under leasing.
I'm not sure yet that you have relied on leasing. If you're looking at 4.1, you're looking at the legal source of something that you could rely on.
Yes.
And it seems to me that the right that you're looking at there, which has been recognised in EU law, recognised by the European Communities Act, is either the right to equal pay, to include the benefit in question here. That seems to be what we're talking about with 4.1. That's not leasing. That's a substantive right, it seems to me.
Precisely.
Yeah.
And so what I'm indicating...
But surely there's no issue about the issue in this case is about procedure,
Yes.
about the jurisdiction of the Employment Tribunal. It is not denied that, assuming this is pay, it's directly, but the question is in what forum.
Right, okay. Well, then I needn't trouble you with that then.
If I'm jumping all sorts of hurdles,
Well,
but I thought that's what this case was about. That's why we've been referring to P and Eckland and so on.
Yes, it is.
And your case is, well, it may or may not be that it's directly effective in the right can be enforced by judicial review or whatever. It can't be. It's got to be effective in the tribunal, and that's common ground if it's pay.
Okay.
If you get into the tribunal, it doesn't matter. You're not going to be relying on Mangold or anything else. You're going to be relying on Section 15 and Section 19. So far as whether or not that provision is acceptable, you're not going to be relying on anything to do with EU law, are you?
Well, we have to rely on EU law to the extent that we have to show it's pay. I'm not understanding your question, my lord. If it's pay, then there's jurisdiction. I think I'm not understanding your question, my lord.
If the tribunal has jurisdiction to entertain a claim that Regulation 12 is unlawful, when they decide whether or not it is unlawful, they will apply Section 15 and Section 19. Does this put people at a particular disadvantage?
Yes.
Is it on grounds of protected characteristic and so on? So if we ever get to the tribunal, what they will be applying is not Mangold or the directive, they'll be applying Section 15 and Section 19.
Yes.
Yeah.
The question is whether or not it's pay, and I'm just pausing there because I may be making things overcomplicated. If it's pay, we're in. If it's general principle, the reason the general principle of equality is important is because it extends beyond IP day, and we know that. May I just track through?
But what you want is, as my lord says, not equality. You want to get into the tribunal.
Yes.
And the thing that allows you to get into the tribunal is a different general principle, not the one that comes from Mango, but the effective and equivalent remedy. It's a separate little principle.
Okay, well then, my lord, I'll
Yeah.
fix. Thank you. As for Bell, it is obviously more problematic.
Mhm.
If you do decide that we're able to rely on the general principle of equal treatment, just bear with me, and it's an attractive argument or it's not. If we are permitted to rely on the general principle of equal treatment, that confers a substantive right, as your lordship put it, and consistent with the general principles of equivalence and equivalence and effectiveness, we can then rely on that in the Employment Tribunal to argue that it has jurisdiction. So in other words, we have another primary right. We have Article 119, pay. We have general principle of equality, which means we can rely on that as a substantive right and say to the tribunal, when you read 15, when you read 19 and so on, you've got to read it in conformity with this general principle. And we then say, and that general principle, that substantive right, must be accompanied by effectiveness and equivalence.
That's one way of doing it. I just wonder whether that makes it more complicated as well. If Mrs. Clark wins, she wins because by one route or another, we interpret Section 61 or 108 as meaning it covers post-discrimination disability allowances. If that's what the words mean, anyone, until Parliament changes it,
Well, then I'm
can
grateful.
claim. And she can get in on the back of Mrs. Bell, on the back of Mrs. Clark, can't she? Unless Mr. Lockley persuades us, because you don't get the benefit just for you. You
My
change the interpretation of the words for everyone.
My lord, thank you.
Yeah.
I'm overcomplicating it and providing too many reasons, which just creates too many obstacles for me. Thank you. So that then is the route we take through the route through Brexit, if I can put it like that. We have Ms. Clark, and as your lordship says, once we've changed, or if your lordships are persuaded, once it's changed, or once it's interpreted so as to include pay, we're at the end of the road. Just like, for example, post-employment discrimination, once your lordships, and courts below indeed, decided that the earlier legislation had to be interpreted so as to include provision for post-employment discrimination, that applied to everybody. So thank you, a long way round that I needn't have taken, but much better by my Lord Justice Lewis. I'm grateful. My lord, that's that point then. The next point is I think it's still said that notwithstanding that, your lordships can depart from the case law that I've identified because you have jurisdiction so to do. I think that's argued in relation to this. So I think it's said by the respondents, even if we get to where we get to and we can rely on the face of it on the 119, 141, 157 cases, this court isn't bound to follow them where the Supreme Court could depart from a decision of its own. And the case referred to is Horton. I don't know, it's not in the bundle. I hope it's been handed up to you by the respondent. This is the respondent's case. Have you?
Not to my knowledge.
My lord, the relevant excerpt is cited in the industrial cleaning case. So, in the attempt to slim down the bundle very slightly, I haven't included Horton itself.
would you be able to give me the?
Well, what does Horton remind me? What is Horton saying anything controversial?
No, it cites the practice direction.
Oh, we know all that.
But well, then I'll just say what I draw from it, if I may, in terms of the impact on the facts of that case. So what the court was looking for, what that House of Lords, Supreme Court, can't recall, drew a particular attention to. This, you'll recall, was the Horton. I don't know if you're familiar with it, but it was a case where the House of Lords had held some years before that if a person issued proceedings within the primary time limit under Section 11 of the Limitation Act and withdrew or terminated those proceedings for some reason, in that case because she hadn't given the relevant statutory notice in an insurance claim, and issue again, they can't then rely on the discretion under Section 33 to extend time. So you've done your Section 11 within the limitation period, you mess up the claim, withdraw or discontinue, issue again, complying with the relevant statutory requirements, and say, well, I am out of time, but can I rely on your discretion under Section 33? Because this was a technical error, and it wouldn't be fair. It would be an injustice to deprive me of the opportunity to pursue the litigation. House of Lords some years ago said, no, once you've issued your proceedings under Section 11, there's a problem with it, you can't use the discretion under Section 33. Horton departed from that, and I just want to draw attention to some points that the Supreme Court relied upon in deciding it was a proper case to depart from their earlier decision. First, it's in the bundle. I beg your pardon. I thought it wasn't in the bundle.
I asked for it to be taken out. But it's
You asked to take it out. Okay, that's fine. Then wonderful.
So where is it?
It's at
Tab 59. Not at all. I'm very pleased. I'm very pleased you did. Thank you. I'm just going to use my copy because I've marked it. Tab 59, did you say? So the facts are set out in the head note, and if I can actually just read you part 2 of the held, so paragraph 2 of the held. Although the House would rarely exercise its power to depart from its previous decisions, it would do so where too rigid an adherence to precedent might lead to individual injustice or unduly restrict the development of the law, that since the reasoning of the earlier decision was unsound, since it was productive of anomalies which lacked principled justification and had compelled appellate courts to draw fine distinctions which reflected no credit on the law, and since it subverted Parliament's intention and unfairly deprived the claimants of the right conferred, they'd exercise their power to depart. And we say we're not in that territory here. There's no lack of reasoning. There's a consistent line of authority. There's no there's no unfairness or injustice in following the Court of Justice case law, quite the reverse. It confers fairness and justice. And there's no subversion of parliamentary intention. So we say consistent line of authority from the Court of Justice, no inadequacies in the reasoning, no unfairness and injustice.
There is at least one Court of Authority appeal case dealing with the power to depart, Underhill, I think it is, and there may be others. And Lord Justice Arnold gives 8 reasons why you shouldn't depart, and the Master of the Rolls give 2 reasons. I would have thought we would have been referred. We didn't have any of the relevant directives yesterday. We haven't got Underhill today. It is usual to refer the court to binding relevant authority, but you're not relying on Underhill, are you?
Well, I'm not relying on, it's not my argument, my lord.
Maybe.
No, it's 8 reasons for saying you shouldn't depart. I would have thought you'd have been relying on one of the 8 But you're not relying on any of
Well,
the 8.
we're certainly saying that so far as the Supreme Court's analysis goes, the facts that they relied upon were inadequate, and we're not in that territory. But my lord,
I'm wondering, I mean, were you going to be dealing with Tunnell, Mr. Lockley? Or no, or is it, it is you,
It's
isn't
Lockley,
it?
it's Lockley.
My lord, I hadn't handed up Tunnell. I was planning to refer you to the industrial cleaning case, which is a case where
Is that post-Tunnell?
the court did depart. I would have to check that, my lord.
Well, Tunnell is a case on the 2018 Act power. Is an Industrial Cleaning Act case on that?
Indeed, yes, it is.
I'm just wondering whether, if neither party's referred to what appears to be the main case on it, whether we ought to just not hear submissions about it now in a half-baked way, but you deal with it in your submissions, and Ms. Monaghan, so far as necessary, reply. But can you see the industrial cleaning case? Where's that?
it's
Tab
tab 72.
Tab 32.
72, page 11001100.
I've got confused myself now. I too have seen reference to, but not read Tunnell. It's not another name for this case, is it?
No.
No,
Is it more recent still?
Or is it? There's not this one.
Someone with a computer here will be able to. It's spelt tunnel with an N on the end.
Tunneln.
It's referred to in industrial cleaning. If I may just take
Where is it referred to? In industrial
1125, paragraphs 80 onward, deal with this point. And Tunnell, is this Warner Music? Tunnell 84. I think that's the case your lordship's relying on.
Yes, a tunnel. It's tune in. Yes, I've seen it written down somewhere. Must be the same case. I agree. Well, maybe we have confused you, but the real point I think both my lord and I are making is that we should be surely the right case to be looking at is not Horton and Sadler and these old cases about the powers of the House of Lords, but the latest case, case about this power, which obviously feeds into that case law, and that is industrial cleaning. And expecting to be taken through it, I haven't myself read through it, but I think this may well be where Lord Justice Arnold
Lord, yes, the departure point is dealt with both by Lord Justice Arnold and Lord Justice Nugent. Lord Justice Arnold is at page 1125, starting at around paragraph 79. And Lord Justice Nugent, I think, at paragraph 114.
This is a hugely important question. One of the things that this court is going to be asked to do time and time again is to depart from the existing EU authority that's arisen over the 45 years of our membership. Really would be helpful to have our attention drawn to relevant case law, especially relevant recent case law at this level.
Yes, my lord. I can ask for copies of tune in, I think.
Tune in,
we'll call
Tunnell.
it is
It's my
tuned in.
fault.
It's my fault
to
as
be
well.
brought up.
But hang on,
as soon
tune
as possible.
Well, I think really that I agree we should see all the relevant case law, and we that may include tune in. I think time spent by Ms. Monaghan on it now, when we haven't had it, how you're relying on it fully developed by reference to the case law, is probably not time profitably spent. You'll have an opportunity, Ms. Monaghan, to deal with it in reply, unless you think that puts you to disadvantage.
No, my lord, I don't see that that's likely.
Thank you.
Okay. There it is. Yep.
Good. Right, so that's cut a little bit out of your notes, Ms. Monaghan, though probably the time we took to cut it out is as long as you would have spent on it anyway.
The next point then is section 108.
Yes.
And of course, we need permission in relation to that. You do have a permission bundle. I'm not sure I need to take you to anything particular. You will have seen.
We've seen in your skeleton why you say that you should have permission to deal with it. I think it's sufficient for us to hear. I'm confusing myself again. I think in this case, Mr. Tolley, on why you shouldn't. But Dibeni Esse, let's hear the, and you can respond to those if necessary and reply. Let's hear the substance of the point.
My lord, if I can ask you then please to turn to page, tab 36, page 453 of the bundle. This is section 108. A person must not discriminate against another if the discrimination arises out of and closely connected to a relationship which used to exist between them. That's not an issue here. B, conduct of a description constituting the discrimination would, if it occurred during the relationship, contravene this act. Now we say when that sentence is read together or in full, conduct of a description which would hypothesise, if it occurred during the relationship, contravene the act, is sufficient to capture the sort of claim we have. This is a badly drafted section, as your lordship knows, but nevertheless, it must be wide enough to capture a case where the detriment or the disadvantage could not have occurred during the currency of the relationship, but necessarily arises out of, is closely connected, and is of a description that would otherwise be unlawful. And if we look at section 39, section 39, page 447, we see that descriptions, subsection 2, an employer must not discriminate against an employee as to terms of employment, as in the way that A affords B, the employee, access or not by not affording B access to opportunities for promotion, transfer or training, or for receiving any other benefit, facility or service. So we say when one looks at the description, it's benefit or detriment under D. Those are the descriptions we're looking at. And if, my lord, it's not approached in that way, one can see what might be regarded as the paradigm case on certain facts, that is refusing to provide a reference because of a complaint of discrimination during the relationship. One can see that falling outside the scope if, for example, entirely conceivably, an employer has a policy of not providing references while a person is employed because they don't want to discourage a person departing. So they say we will provide references, but only we have a policy of not providing references during employment, but once the relationship is over, we will do so.
I'm just puzzled by the introduction of the words of a description. I see your point. You say the descriptions are to be found within the act. But if those words weren't there, what would you read? If it just said the conduct, if it occurred during the relationship, would contravene this act? What,
Well, my submission, we wouldn't lose anything. But the respondents say, unless you have, because of the way would have occurred is drafted, that means it precludes any reliance on a disadvantage or a detriment that could not have occurred during the relationship. So the respondents say one has to look at whether the conduct could have been unlawful during the relationship, if it occurred during the relationship. And we say, well, even if that's so, we say you're entitled to hypothesise, but even if that's so, it's conduct of a description we're looking at, not anything. So even if we need some way in, we say doesn't go further, it doesn't help. What we're looking at is conduct which would have been unlawful or which comes out of the relationship and is otherwise unlawful. And of course, this is a freestanding tort. So it's not it's a freestanding tort. You can rely on this as an unlawful act where those conditions are met. And if I
Another way
may,
of looking at it, and it's really more for Mr. Tolley to think about when he addresses your submissions, is that this 108 isn't referring to section 39 at all. This is the definition of conduct, which is in part 2 of chapter 2, and the conduct is the different types of things: discrimination, unfavourable treatment on grounds of a protected characteristic, failure to make reasonable adjustments. And all you've got to ask is whether or not it's that type of conduct, unfavourable treatment on grounds of age in this case, for example, and you don't need to tie it and decide if it would have breached section 39. So the heading is prohibited conduct ancillary, and it's just including within the range of things that are capable of amounting to discrimination or unlawful actions, things after the relationship which come within those sections and which are directly or closely connected with employment. That would be another way of putting it, but that's not the way you put it. But Mr. Tolley may want to think of it in those terms when he's making his submissions.
yes, my lord, I'm grateful again. And if I can ask you please to look at the legislative history, just the predecessor legislation, so we can get some idea of what was anticipated. And may I just say as well that, of course, when we moved from the predecessor legislation to this, it was, of course, that the provisions were expanded to cover non-employment discrimination. But if we look at tab 30, page 271, and section 16A, which is at page 271, in my submission, this is what was intended. So subsection 1, this section applies where there's been a relevant relationship between the disabled person and another person. Pausing there, we're looking at disability here because this is the Disability Discrimination Act, and we're in discrimination territory.
Yes, though in fact there was equivalent language for all the different
There was.
protected, for all the predecessor legislation covering particular kinds of prohibited conduct, sex, so on. Yeah.
Precisely. I use disability because that's a territory.
No, that's perfectly sensible.
But yes, my
spelling
lord,
that out.
yes,
Yeah.
my lord. So what we're concerned with, is there a relevant relationship? Well, we know there was here. We don't need to trouble you with that because it's defined at 2. B, the relationship has come to an end. Yes. In fact, I probably should read 2A. A relevant relationship is a relationship during the course of which an act of discrimination against or harassment against a party by the other to it is unlawful under the preceding provision or part. So in other words, we're looking at whether it's a relevant relationship, whether it's come to an end, and whether or not during the course of that relationship an act of discrimination could have occurred. A relationship during the course of which an act of discrimination by the other party is unlawful under preceding paragraph. So
so it doesn't use the language of would be.
Precisely.
It just says it more clearly. Is it that kind of conduct?
Precisely. Well, it says, could you discriminate in the context of this relationship? And if you can discriminate in the context of that relationship, then you can rely on a case post-employment. And in that context, what is made unlawful, that having been the circumstances in which the section applies, subsection 3, discriminate by subjecting to a detriment and harassment where it arises where it's closely connected. So one can't have, there must be a close nexus or a sufficiently close nexus. And in my submission, it can't be said that there isn't a sufficiently close nexus here. There might be if it was 40 years later and somebody had remembered to apply for a luncheon voucher. But we're not in that territory. So we say we're sufficiently close.
Well, there's no issue about it, is there? Because I think I've understood that the only issue is about 108B, not 108A.
Mr. Tolley takes a different view in his skeleton, I think. I think he says it's not 108A either.
Quite so.
So sorry. Well, I haven't read the skeleton carefully enough. Right.
So we simply say that's part of the legislative history. We also rely on your observations, my lord, in Rostock and Jessamy, tab 61, just shortly. I didn't trouble you with any of the detail. But 61, tab 61, page 863.
This was about the mistake in not including victimisation in the kinds of post-termination conduct.
And it's really just it's really just one point where you observe, my lord, at paragraph 31, or you was I think I might have been.
Well, it just makes the very basic point. I'm not sure we even need to go to it. That
it wasn't intended.
That the Equality Act, though not technically a consolidating act, was not intended, clearly not intended, to reduce the rights of potential victims of discrimination compared with the rather messy pre-2010 Act regime where they all had their different bits of legislation.
My lord, that's precisely the point.
Yeah.
So we say precisely that. It wasn't intended to reduce protection. It's not a terribly well drafted section. It's part of the context, but nevertheless, what we can deduce is having regard to the legislative intention provided in all the legacy enactments.
If you're right, sorry, it's just allowing me to release a bee from my bonnet for a second. The Equality Act repeatedly tinkered with the drafting of previous legislation, which was well understood, introduced new words, new concepts, and nearly always made a mess of it. So we must have had at least half a dozen cases in which problems were caused by unnecessary tinkering with previous wording. They've nearly always been resolved in favour of restoring the law as it was before.
Well, I don't know
you
if
need
it's
to say
always
anything.
been,
I just
but in any event,
this has annoyed me so much I can't help saying it.
Well,
from time to time.
the Equality Act is not an easy act in my submission in any event, but certainly post the 2010 Act, it's given us a lot of work. So we've got barristers
Anyway,
have got that
yes,
to be grateful for.
I'm wasting your time.
So simple point, we say it must mean that it covers a situation like ours, and indeed if one wanted to look further we can look at the legislative history, and it's plain we say, particularly having regard to your comments in Rostock, that it wasn't intended to reduce protection. It's a short point, but in my submission we say it's a clear point.
Concede in EAT that 108 wasn't satisfied. If so, do you need to withdraw the concession?
I'm not sure there was a concession,
Oh, okay.
and I'm pleased to see Mr. Lockley's nodding,
No,
not suggesting there was.
No,
That's not a problem then.
quite the opposite, my lord. The last paragraph of the judgment in my submission makes very clear that there was a concession.
There was a concession, did
Yeah.
you say? Oh, I'm sorry.
Well, I must say I'd assumed that there was a need to withdraw a concession, but that was all That's why
part and parcel.
that was all part and parcel of the application.
I think the concession was made on the basis that if 61 applied, section 108 didn't. But in any event, perhaps I don't need to try, I wasn't there below, and perhaps I could just say, to the extent if there's a dispute about it, may I submit that the way to resolve that is by the substantive question, should we get permission? We say there's no disadvantage, the opportunity to argue it below, having been granted, the opportunity to make submissions on permission was granted below. So there's no additional prejudice. And my lord, may I just observe as well that the application to amend was made very shortly after the application for permission here, very shortly after the notice of appeal was lodged here, and the respondents had the opportunity to address it in their respondent's notice and in their skeleton argument. Of course, the prejudice is they have now got another argument to meet that they didn't expect to meet, have to meet. But in my submission, that is the only prejudice. I don't.
That can be quite significant prejudice.
Yes,
in some cases.
My lord, precisely. I was about to say that I don't for a moment say that is not significant, but it's not in my submission of great significance, given that this was dealt with very shortly afterwards.
The reason why the case wasn't argued on this basis in either of the in the court on the first appeal is as it were oversight, is it, or change of view since, putting it a different way?
Perhaps that would be a better way, my lord. I can't say any more than that, really.
We don't have any evidence about it.
No. Well, the evidence is in the witness statement of my instructing solicitor in the permission bundle.
Well, perhaps we better just look at that.
Yeah.
It's at. Do you have the permission bundle in
Yes.
front of you? And then if you look, please, at page 9. And you'll see there's some introductory there's an introductory paragraph under paragraph 4 about the importance of the claim to other officers. So in other words, there's a public interest context, but then at paragraph 6, the appellants advance their claims in the Employment Tribunal under section 61 and 108 as alternative causes of action, and contended that the Employment Tribunal had jurisdiction to hear their claims under one or other provisions, determined it had jurisdiction under section 61 but not 108. Appellants did not seek permission to appeal the decision of the EAT, though they were granted permission in relation to 61. And then paragraph 7, advice was sought from leading counsel. In light of that advice, a different...
Mr. Lockley makes the point that this isn't a completely full account of what actually happened in the EAT, I think.
Yes, my lord. This is actually a matter I believe Ms Hodgetts will be addressing in more detail. But if one looks at paragraph 99 of the EAT's decision, it's quite clear that the way it was put before the EAT was to say, well, we recognise that section 108 is weak and in fact hopeless, and that very fact drives you to the conclusion that it has to be section 61. Now,
Yes, all that
maybe
can
a
be
comment
said.
now about the merits of that argument, but certainly the way it was put is that section 108 is a non-starter. Therefore, that's a further factor in favour of section 61. That's perfectly clear from paragraph
They were
99.
saying we have to win on something. We think it's an occupational pension, but if we're wrong on that, we'll have 108. But there was no argument, I get the impression, on the meaning of section 108, the wording. legislative history or anything like that.
My lord, it goes further than that.
Oh.
The express submission was, because we accept we can't succeed on 108, therefore we must succeed on 61. We accept that ET made no error.
Oh, right.
Well, does it go, well, that's not, we get from 99.
Oh, well, 100, last sentence, my lord.
Oh, 100.
Formally speaking, then there was a ground of appeal on that.
There was, but it was.
It's effectively, what is being said is that in the course of oral submissions, I think not before oral submissions, Mr. Feeney accepted that he couldn't effectively challenge. That's what is being said. And we weren't there, and I'd be reluctant for this to turn on the detail of what was said, but one does know that sometimes you make forensic decisions about what to press. You may say, well, I haven't, in discussion with the judge, you may say, well, I can see my real point is this. Or one just doesn't know, and without a transcript, but it really shouldn't turn on this sort of point. But
with respect, it wasn't the case of which of my stronger points. It was positively advanced. The submission was positively advanced. That because the ET was correct about.
well, you're telling us this. I'm not sure Mr. Feeney would agree with that.
Well,
At the moment, I'm not sure we want to get into this at this stage, but you were saying it is clear from paras 99 to 100 that particularly 100, because I think it's only the phrase "as the claimants accept," the ET made no error of law in its reasoning. And that clearly records a concession made in the course of oral submissions. All I was saying was that these concessions made in the course of oral submissions are perhaps of a somewhat different character and weight than concessions may be made in advance of argument in written submissions or points not taken at all.
Well, my lord, in Mr. Feeney's skeleton argument, but before the EAT, there was, whether it fully amounted to a concession, I would have to check, but there was certainly a forerunner of the point as you see it in the EAT's decision.
I see.
I believe the words we don't advance a positive.
Well, we've
case
come
of
at this
one.
in a slightly half-baked way. It's my fault. My lord quite rightly drew attention to the fact that the giving permission to revise this round of appeal necessarily involves giving permission to withdraw the concession recorded in the final sentence of the EAT's judgment. And that's obviously right. So if we are going to have to explore the circumstances of the concession, we've got to do it, I suppose, properly, but only on the evidence before the court. We have the claimant's solicitor's evidence, which you say isn't quite right, because it's not consistent with what the EAT said. I think I'm inclined to think the right thing is for you and or Ms. Hodgetts in your submissions, as you were both there, to draw our attention to any material you think is relevant as to why the concession shouldn't be withdrawn, and as to, if you like, its precise character, and then that can be dealt with in reply by Ms. Mullen.
Yeah, yes, my lord. I think having very helpfully drawn out that issue, the right thing for me to do is sit down, because this is a matter of misogyny.
No, I'm not blaming anyone. This sort of thing happens in the course of oral submissions, but I think we risk becoming undisciplined unless we deal with it in that way.
My lord. So I require permission, and
Sorry, you
so
require.
we require permission. No, I didn't say.
I thought for a moment you said I have acquired permission. it seemed an odd thing to say, and it isn't what you said. So
the
that's
level of
good.
inarticulacy I'm demonstrating. Would I presume to suggest that's the position? So yes, my lord, we require permission. You've seen the way it went. There was a concession. I'm told by Mr. Feeney that essentially the argument was it must be 61 because it's got to be something, and it's not 108. So I think it can be said fairly that there was a concession. We do have to. It was argued fully below in the Employment Tribunal, and it was, of course, a ground of appeal.
Yes, I see. So perhaps the only missing piece of the jigsaw, which may not be central, is to see how it was put in the appeal to the EAT, whether that concession happened there. As I do think that there can be a distinction between concessions made under pressure, not under pressure, but in the course of a dialectic process with the court, and things which have been conceded from the start. All right,
Well, it was the middle way between those two. There was an appeal on it,
yes.
and we exchanged skeleton arguments. We put our Section 108 cases, and when we received Mr. Feeney's skeleton argument, it said we're not advancing any substantive case in Section 108. So there was a considered decision in written submissions to make that concession, or certainly a formal.
Okay, well,
Do we have the skeleton arguments in our bundles for the EAT?
My lord,
Focus on it if we have them.
I'm so sorry. I rise because, as the learned friend has indicated, it may fall to me to address the Section 108 point. We don't have the skeleton arguments for the EAT in the bundle, my lords, but we do have the respondents' joint response to the permission to appeal application, which quotes the relevant section from learned friend Mr. Feeney's skeleton argument. That is at page 14 of the permission to appeal bundle.
can't be 40. 14,
My
sorry.
lord. And the relevant passage is at page 15.
Yes,
at
I see. No. Yeah.
So it's only put in 54 on EU effectiveness grounds. It's not put in terms of the wording of 108, is it?
No, that's
Yes.
correct.
Yeah, well,
my
thank
lord.
you. That's very helpful. I'm embarrassed I haven't picked that up before, but I was waiting to be taken through it, is my only excuse. Well,
Well, my lord,
I still think better. I think we've now, rather in an undisciplined way, got out all the material. Let's see what Ms. Hodges, who I think to take the burden on this, makes of it in her submissions, and you can deal with it in reply.
my lord. Just one matter then, finally, I think, I hope, and that is, my lord asked yesterday, well, how do we say the relevant provision should be interpreted if there is an interpretative obligation arising under EU law? Well, in relation to section 108, we say, even if on the face of it, it's drafted in a way suggested by the respondents so that it doesn't allow for the claim here, we say it can plainly be read in a way that it permits the claim. And in terms of leasing, I mean, one would go much further than
How
that.
is the question? When I look at the words, which words do I mean as reading Monday rather than
If I
Tuesday?
can take you back to tab 36, and that is page 443, it starts, and if
Yeah.
I can just take you to 108, page 453.
But looking at section 61 first, do you say that I've lost the words on now. You say the word
No,
mean.
well then, my lord, the thing with section 61 is, of course, it imports section 1 of the Pensions Act.
Yeah.
So we have the amendment we need to
Well,
make,
it
or
is
the
a Pensions
interpretative
Act, yeah.
exercise applies to section
Yeah, so
1.
one, yeah, and you'll be saying it means during or in retirement.
Yes,
rather
or
than-
capable of, be read in a way that I've invited your lordships to.
That's a different argument. That you're using capable of to make the domestic law point that that's what on means. We're assuming now you've lost on that, and it's only an assumption. And then you've got the word on in 3 subsections, and you have to tell us what you say the word on should be read in the leasing. And I thought you would be saying that certainly on little a meant during or after.
Yes, precisely.
Yeah. So the Pension Act, on means during or after.
Or even, I mean, it's just after. Yeah,
means
it's
after
just
then.
after. So it's on or after, because we're not concerned with during, because this is a post-employment benefit.
Right. So you want me to read section 1, see what it was, as mean when it says on termination, on or after termination.
Yes.
Those are the two words that I'll add in to make it sensible. Like in P, they added in about 20 words. You read in the words on or after, and then under section 108.
Well, section 108, of course, I'd invite you to construe it again in the way we've identified, but assuming we've lost on my
Yeah.
point, I recognise that, then we would simply say, we would simply ignore if it occurred during the relation conduct of a description constituting discrimination that would contravene this act, or well, that would get the same thing. Constituting, well, in fact, you could delete the whole of that line. Must not discriminate. Discrimination arises out of, is closely connected to the relationship that used to exist between them. So you've got to read in victimisation, because of course it doesn't cover victimisation, which Jessamy dealt with.
So I'm looking now at 108.1a, and I'm now construing this for pay only, it seems. So what do I do? Say the discrimination arises out of and is closely connected to a relationship which used to exist between them, and brackets, save in relation to pay, close brackets, B. Is that what you're saying? That B doesn't apply to pay?
Why would we not want pay? It's my fault, my lord.
No, we've got to change. You're asking us to change words, you see, in an act, because you say it's pay. And therefore I'm wondering what words I change. Just like in section 1 of the Pensions Act, I now know I add 2 words, or after. I'm now looking at 108. And you started by saying you delete some things, or read out some things, or ignore some things. Then you said read out the whole of it. But since all we're doing is dealing with pay, the only words you want read out, the only limiting words you want read out, it seems to me, are B in relation to pay. So I thought you were saying that in order to be within 1.8, in cases involving pay, you only have to satisfy A, not B.
Yes. So in other words, we just delete B altogether for the purposes of pay.
Yes, that's what I'm saying. So,
yes,
and save in relation to pay, B. That's what I was saying.
Sorry.
Wouldn't that be what you're saying? Or?
Yes, yes. It's and in this context, B doesn't add anything. It's my lord, yes. I mean, the domestic law constructions, in my respectful submission, seem the most uncomplicated and justified given the legislative history. But I accept that if we need to rely on EU law, then, and that is a much, as you lordships indicated, that is a much less brutal, if I can put it that way, construction than we've seen in some of the other cases, including in this sphere.
Right.
My lord, those are my submissions, unless I can...
No, thank you very much. Yes.
If I could just have a moment to sort my arrangements out. Thank you. What you will have gathered in a rather roundabout way, my lords, perhaps not in quite the planned arrangement that I had in mind, was that the structure of the submissions from this point forward is as follows. That I'm going to address ground 1 in response to the Lady Chief Justice's nudge, amongst other things. My learned friend, Ms. Hodgetts, is going to address ground 3, including the permission point. Mr. Lockley is going to address ground 2. You'll have seen that we each, the third respondent and the first and second respondent respectively, mutually adopt each other's written submissions. I haven't heard Mr. Lockley's oral submissions yet, but I anticipate saying formally in due course that I adopt them. As between the respondents, I'm assuming, unless your lordships tell me otherwise, that we'll take the grounds in order. In other words, that I'll stay on my feet now and continue with the response on ground one. And that does have at least this advantage, that having endured my submissions on this point, your lordships will have something to look forward to. Can I do a tiny bit of correction first before I get into the substance? The dates set out.
Sorry, it's just about order of submissions.
Yes.
You'll deal with ground one.
Yes.
I would have thought it made sense for analytically for Ms. Hodgetts then to deal with ground three before Mr. Lockley, because we need to understand where we are on the purely domestic law before we get to EU law.
Very good.
Yeah.
I'm sure Ms. Hodgetts won't be in any way perturbed by that slight rejigging of the anticipated word. And the slight correction I wanted to make to the two dates in the respondent's, the third respondent's skeleton argument. Paragraph 2, two dates are given there for the date of retirement, respectively, of each claimant on the ground of Underhill. In relation to the first claimant, Ms. Clark, first appellant, the relevant date is stated as the 15th of November, 7 lines down, 2019. The correct date is the 15th of February, 2019. And as to the second claimant or appellant, Mrs. Bell, the date is stated in the penultimate line as the 9th of November, 2018. It should have been the 9th of December, 2018. And neither date may matter to my lords, but I just didn't want your lordships to get a misleading point of fact.
So where's the second one?
The second one's penultimate line of paragraph 2 says the 9th of November.
Yes,
should
I
be
see.
corrected to the 9th of December. I mean, neither of those dates is actually in the chronology your lordships have at page 44. I'm not sure anything turns on it, but let me just get the facts straight.
Yes, okay, thank you.
So moving on to, if I may, a general overview before I get to the specifics of ground one. I just got a few points to make sure that my lords have. Obviously, this appeal arises as a result of a preliminary hearing only on certain jurisdictional issues. Whether there was any claim capable of adjudication in the Employment Tribunal, as my lords rightly put it earlier, it was a procedural point in that sense, a jurisdictional procedural point. And it was a point common to all of the respondents. There has been a separate adjudication in Mrs. Bell's case of a time limits point.
Yes.
Your lordships may have picked that up. There was a judgment on the 16th of May of last year in the Employment Tribunal. The reference is page 100 of the supplementary bundle. And there's an appeal pending at the EAT SIFT stage. The issue is
But that's been stayed pending the outcome of this, has it?
I'm not sure it has been
I see,
formally stayed.
okay.
I think it's just in the
taking
long
time.
queue.
It's taking its time.
There are further common issues yet to be addressed.
Rather odd to have an appeal about whether there's jurisdiction to hear her claim when her claim is out of time anyway.
Well, there's a separate jurisdictional objection, my lord, and it's been dealt with on a separate stream.
Here we
That
are.
was the case management in the Employment Tribunal. I can neither claim credit or take the blame for it. But that's what, as my lord says, that's where we are. I just wanted to draw attention to there being two further common issues yet to be adjudicated, if they should turn out to be relevant. The first, obviously, is the substantive question of whether what we're calling the 12-month rule involves discrimination arising from disability or indirect discrimination. That hasn't been adjudicated. And if it does, whether it can be justified.
Yeah.
There's also a further line of points to draw to my lord's attention in respect to what I will say is the slightly unusual premise of the claim against the third respondent, the Secretary of State, is the primary basis on which the claim is put is section 111 of the Equality Act, causing, inducing, instructing discrimination. And what is said essentially is that by enacting the regulations, the Secretary of State has instructed, caused or induced the contravention by the Chief Constables. Now that's a disputed point, as my lords will imagine, yet to be adjudicated. It only arises obviously in relation to the Secretary of State. there's a second point of law, whether the relationship between the third respondent and the chief constable is such that the third respondent is in a position to commit a basic contravention. And if I can just ask my lord.
Sorry, these are very interesting points, but they don't arise, and your time is short.
Well, very good, my lord. I just wanted to make sure my lords understood where the points we have sat in the overall legal structure. That was all. But I do take my lord's point about time. And that the final question is a time limit point. If there was an act of discrimination by the third respondent, when did it occur? So, taking my lord's prompt, moving to ground one, and then some specific points by way of overview in relation to ground one, please. And just for my lord's note, the references are paragraphs 10 to 56 of the Secretary of State skeleton argument, paragraph 68 to 81 of Mrs. Justice Eady's judgment, that's core bundle pages 75 to 81, and the respondent's notice if we need it, paragraph 1, core bundle page 120. So coming to the specifics on ground one, it is at its heart a short point of statutory construction of section 1.5 of the Pension Schemes Act. That's where we get to. Won't waste your lordship's time by taking you through the route. You've got there already. And just to make sure my lords have all the references in one place, the current version of the subsection is at page 294 of the authorities bundle. The original and unamended version is at page 226. And the amending provision is at 279. Took effect on the 1st of July 2005. Now, before my learned friend's one-hand submissions yesterday, I had understood that the argument to be put to your lordships was whether Regulation 12 of the PIBR or the regulations more generally was a scheme or other arrangement having effect or capable of having effect so as to provide benefits, etc. But following those submissions, I have certainly understood that the question is reduced in scope in two respects. The emphasis is entirely on whether Regulation 12 on its own is capable of having effect so as to provide benefits, etc. So in other words, the focus has become only on Regulation 12. It's no longer being said, or certainly no submissions were directed to this proposition, that the regulations more generally, and in particular Regulation 11, satisfy the test in the Pension Schemes Act. And there was no attempt, certainly that I detected, to argue that Regulation 12 itself had effect so as to provide benefits on retirement or on termination of service. My Lord Justice Lewis, I've got a note of this, asked my learned friend what she said was the meaning of on, and she neatly sidestepped and proceeded to make a submission about capable. And my submission, that's telling, because there haven't been any submissions about the meaning of on, save as we at the end of the debate.
On a different basis.
On a different basis. But on the matter of domestic construction, putting it, and I hope keeping it in a nutshell, there is no longer any contest, so far as it appears, on the meaning of on in the statutory language of section 1.5. Now, if the court understands the position in the same way, I could be a good bit shorter. I don't want to, as it were, hold any swords over the heads of members of the court, but what I certainly don't want to have to do is go through academic points, which are no longer in contest, as between myself and my learned friend.
Well, speaking for myself, as I understood it, Miss Monaghan is saying, look at the word capable of having effect. That must mean it can't just be on retirement. The fact that it's capable of having effect on retirement must be given something. So the fact that it would be coincident with retirement in some cases, but not coincident with retirement in other cases, it doesn't matter, because it would be capable of having effect on retirement. So the really interesting question is, what do the words capable of having effect mean?
Yes, and I obviously will address that directly.
That's critical. That I would like to hear about.
Of course.
Well, I think Lord Justice Lewis speaks for me as well. Doesn't look as though you need go beyond your skeleton on the point on the meaning of on without the context of capable of having effect. I'm not saying we, because those submissions have not as such been challenged. Speaking for myself, I see the force of them. You're happy with that as well? Yeah. But no, it's focus on capable of.
Very good. I'm going to do that. There are some preliminary points I need.
Yes,
to,
of course.
To do
No,
before
don't
we-
say anything. If you wanted to steer, that's the steer. But we're not stopping you making any submission you want.
I've taken that point very clearly, but what I'm not going to do is waste your lordship's time with points that are perhaps uncontested or of no contest in the substance. And I just wanted to focus, if I can ask my lords to turn up, please, the relevant definition, just to have it in front of me at 295 of the authorities bundle. It's the first volume, tab 44. Can I just say, for my own purpose, I'm going to be primarily referring to the first authorities bundle. There might be one or two trips to the fourth, but mostly the first. And just to draw to my lord's attention before we start, a point about the distinction between A on retirement and C on termination of service in an employment. I mean, certainly the focus hitherto on behalf of the claimant seemed to have been on C, on termination of service in an employment. And where you've got an employment, it's not obvious what A would add, because retirement would simply be a subset of a termination of an employment. But obviously there are other types of case, let's say a case of a director's pension scheme, where there might not be an employment. And so that's why one needs on retirement as well. And we'll come to one of the decided cases which proceeds on that premise.
Police officers are not in employment.
Quite so, they are office holders,
Yeah.
quite similar. So it may be, although for the purposes of the Equality Act, they're treated as having an employment. But my lord makes a perfectly good observation. So perhaps the right reference ought to be on retirement, including termination of an office akin to employment.
I just thought termination of service in an employment meant you'd left that employment, you'd stop being a police officer, and you'd become a barrister or something. And on retirement was when you'd reached an age at which you would cease to be working. That was what they had in mind. An ending of all work as opposed to an ending of unemployment, hence the words termination of service in unemployment. But I don't think it matters.
Well, it may not matter, my lord, but your lordship makes, if I may say so, a fair observation about that possibility. Now, I needn't go into this in as much detail as I had previously contemplated. But the starting point, if I may, and the summary of the points I rely on are at paragraph 12 of the skeleton argument, just to expand on them in that order. And the first is the most important in some respects. What is the natural and ordinary meaning of the statute? If I can ask my lord please to turn up and I apologise, this is the one exception to my list of references in bundle 1. The second authorities bundle, tab 73, 1138. And that's just an extract from Billion. And if I can invite my lords to turn on to 1152, section 11.4. And all of this will be completely familiar to my lords. The particular point I wanted to draw to my lords' attention, which in my submission put the substance of the submission much more effectively than I could hope to achieve, is the quotation from Lord Steyn at the foot of the page on parliamentary drafting, where there is precision involved. The Lordship says a bill is not there to inform, to explain, to entertain, or to perform any of the other usual functions of literature. The bill's sole reason for existence is to change the law. The resulting act is the law. And his Lordship goes on to say that a bill cannot set about communicating with the reader in the same way that other forms of writing do. It cannot use the same range of tools. In particular, it cannot repeat important points simply to emphasise their importance, or safely explain itself by restating a proposition in different words. And his lordship concludes by saying legislation speaks in a monotone and its language is compressed. And it's particularly that in my submission really speaks to the drafting of section 1.5 of the Pension Schemes Act. The next reference I wanted to show my lords back to the first authorities bundle, tab 32, page 289, is the admissible aid of the explanatory notes to the amendment in the Pensions Act 2004 to this provision. And if I can ask my lords to turn on to page 290 and paragraph 871. It's only one sentence, 6 lines down. New subsection 5 defines a pension scheme for the purposes of section 1 as one which provides benefits on retirement and having reached a particular age or on termination of service. Now, I appreciate that's just a summary, it's a one sentence proposition, but it doesn't suggest any support for my learned friend's argument that the capable of formulation is somehow massively widening. The next observation, if I may, is that of course this act is what one might call a multi-jurisdictional definition. It's not there for the purposes of the Equality Act, it's been borrowed for the purposes of the Equality Act. And of course, amongst other things, it determines the jurisdiction of the Pensions Ombudsman, it regulates the administration of pension schemes and the protection of scheme members. So I would simply say one needs to bear that wider statutory purpose in mind, both in interpreting it and, contrary to my primary submission, if we get there, potentially adjusting it. And then if I can ask my lords to come back, please, to the provision itself at 295, at 34. Actually, if I can ask my lords to start at 294, please, because of course, where we get to the definition in subsection 5 is from subsection 1. An occupational pension scheme means a pension scheme, so that picks up the definition in subsection 5. That, for the purposes of providing benefits to or in respect of people with service in employment of a description, or those people and others. But my point in emphasising that is that the drafting focuses on what I will call the crystallisation of the benefit. That is what's required, nothing more and nothing less. But the important proposition in my submission is that it should necessarily be so. That the relevant event brings about the benefit. And I'd invite my lords to test the point in this way in relation to subsection 5. In any of the identified events, retirement, reaching a particular age, termination of service, would a claimant thereby be entitled to benefits under Regulation 12?
Can you say that again?
In any of those events, taken on their own, retirement, reaching a particular age, termination of service in an employment, would an individual, let's keep it general, nothing to do with any particular individual, would any individual thereby be entitled to benefits under Regulation 12 of the Police Injury Benefit Regulation? And I would submit that the obvious answer is no, it's not enough.
Because termination isn't enough and retirement isn't enough.
Quite so.
You've got to have injury and permanent disablement.
Quite so.
And they're not related.
Well, that's an additional point. But my friend made some submissions in her skeleton argument, and there were one or two hints of it in oral submissions. The references in her skeleton argument are 61 and 65 about what might usually be the case. It was contended that the injury benefit regulations provide benefits on retirement to, the way it's put, the vast majority of officers. And it usually happens She says the disablement occurs
May
prior.
be coincident with, but you say it's not the cause of.
Well, it's similar, but what I say, I don't accept those propositions as a matter of fact in my learned friend's skeleton argument, and there's no evidence about it. There was none before the ET, and certainly none before your lordships. Just briefly, if I can just explain a point, if I may say so, my Lord Justice Lewis had it exactly yesterday. The references to the Income and Corporation Taxes Act, that's bundle 1, tab 24, page 2.5. And the reference, I'll explain it with this point in mind, and also in relation to ITPA. As my Lord rightly observed, in this context, the point is simply to show the variety of statutory expressions available. Not making a substantive point of tax law, but one sees in the definition of relevant benefits at the foot of 215, the options of on death, in connection with past service after retirement, on or in anticipation of or in connection with. All sorts of formulations available. Just to draw to my Lord's attention so that it's not missed, at the top of page 216, the last word's 215, except, and it does not include any benefit which is to be afforded solely by reason of the disablement by accident, and the person occurring during his service, etc. Thankfully, my Lords don't have to construe those words, they're no longer the words, but just to make sure my Lords see that there was an exclusion in the Income and Corporation Taxes Act. The same points really in a different way arise with the current legislation, ITPA. My Lords have that at tab 28, page 238. This is an earlier print of the section, but the section is still in force. In a different version.
Sorry, could you give the page number?
Yes, of course, my Lord. It's page 238,
238.
section 393B. What my Lords have is the very earliest formulation of this section in the bundle, but as a matter of substance, the definitions remain the same. And my Lord, what my Lords see here is the definition of relevant benefits in the currently applicable tax legislation. Again, subparagraph A, on or in anticipation of retirement, on death, after retirement or death, in connection with past service, and so forth. It's only so that my Lords see that when statute has in mind a particular compressed form of language, it's well able to adopt it. Just so that my Lords have it, we'll come back to it, it's a much more minor point. The definition of excluded benefits in subsection 3A, I'm going to come back to that point where it belongs, but just so my Lords have it now. So what I submit, my Lord, when one sees the use of this kind of language in this kind of legislation, it is used with a particular precision in mind, and one therefore has to understand it carefully. What I'm going to do before dealing with the cases is come now to my learned friend's case on capable of having effect with those preamble points in mind. The starting point is that the original version of the definition, see page 226, that's tab 26. The original version of the definition had this language, has or is capable of having effect. One sees that in the second line of the definition of an occupational pension scheme. The structure, as my Lords have picked up, was a little different. All the effective language was contained in the definition of an occupational pension scheme or a personal pension scheme, rather than there being separate definitions of what pension scheme meant, and then within that, occupational, personal, public service. And in response to a question my learned friend Lord Justice Lewis raised yesterday, the amendment in 2004 was not a consolidation, but an amendment, because my Lord will see, amongst other things, but the original definition included in the third line on death,
Yes, so that's gone.
and that was deliberately taken out.
Your point is capable of having effect, payable on termination. They're capable of having effect, as I understand it, your point is, it's still connected with payable on, not just capable of having effect and might coincide with.
Quite so.
Yeah.
Quite so, my lord.
As my Lord Justice Warby pointed out, the payable's gone.
It has, but let me explain how we get the equivalent in the current version. The second observation just to make is none of the cases that have been cited to your lordships, it's not a criticism of them, but it's simply a fact, are directed to this point. What does capable of having effect mean? Although there is a useful, I'll come to it, a useful illustration of how it might work in the odd case of Parlet and Guthrie. I'll come to explain that. But while I say that the words capable of having effect, and so just so that my lords see them in their current context, 294/34. So having seen the definition of an occupational pension scheme, and then going over to the definition of pension scheme, is that the having or capable of having effect formulation is so as to provide benefits to your respective people. And in my submission, what those words capable of having effect are doing is to enable a court, or an ombudsman as the case may be, to tell whether a particular arrangement amounts to a pension scheme before it starts making payments to anyone or to the particular individual in question. Because if you merely had the words having effect so as to provide benefits, you couldn't apply the definition to a scheme that was drawn up but not yet paying out, or not yet paying out to any particular individual, because it wouldn't have had effect yet.
And why would you want to know? Are there reasons why you want to know?
The reasons why you might want to know, my lord, for example, in the pensions context, if there's said to be some maladministration of a scheme by its trustee, it was investing in the wrong things, you might want to contend that it was a pension scheme subject to regulation under the Pensions Act, and then there might be a dispute as to whether the scheme was or wasn't a pension scheme.
I see your explanation, but it holds a very pedantic view on the part of the draftsman. If it had said having effect, but you had a situation where the scheme was not yet making any payments, would anyone really think of saying, well, this isn't having effect? The phrase having effect because no payments are being made, anyone would construe having effect as meaning the legal effect of it is that payments will, on the occurrence of the relevant events, occur. So I see what you're saying, but it as I say, it's across an extremely pedantic, precautionary approach.
Well, if I may say so, that pedantry in drafting is a characteristic of this kind of legislation, both tax and pensions legislation, because of the need for compression. And
But if your submission is right, one wonders rhetorically why we need the words having or, because capable is broader and having or will fall within it.
well, one might have a pension scheme that had already paid out, in a sense, in full.
Yeah, but
But there
that would necessarily be capable of having effect, provided it isn't one.
I mean, in my submission, I take my lord's point, but in my submission, what it's trying to get at is in the sense of potential.
What this provision is doing is describing which schemes are OPSs and which are not.
Yes.
It's not dealing with individual cases, individual payments. It's the scheme. You could have said a pension scheme means a scheme or other arrangement comprised in one or more instruments or arrangements for the provision of benefits too.
Well, so, my lord, it's a scheme-based test, as your lordship rightly says. It's not about the particular case of a particular individual. You have to be able to tell in relation to the scheme whether it's having effect or capable of having effect in these ways.
So the key thing is a scheme to provide benefits to or in respect of people. That's the key thing you say. And the having or capable of having effect is just a rather grandiloquent way of saying that. Why use one word when you can use 46 as a draftsman?
Well, the concern would have been in that context, I would suggest, with, of course, my lord, Justice Underhill points in mind, that having effect might be said not to apply to a scheme that had not yet had effect.
But you said, well, you could just take out all the words. It means a scheme or other arrangement to provide benefits.
Yeah.
You don't even need having or capable of having effect so as to.
That's true, my lord. It may just be that because those words were in the original iteration of the statute, it was felt that taking them out would cause more concern than leaving them in place, because one might have thought there had been a change in the law, whereas on my lord's
See my observations about the Equality Act.
I mean, what I would say,
But is that an answer? Because doesn't the same problem then arise about their meaning in the original version? You say, well, they were there in the original version, so they may be a bit redundant, but they see why Parliament didn't take them out. But were they redundant in the original version? Or is the drafting of the original version?
at page 226, see the original version. That was
Is it
drafted slightly different.
2226.
2226. Slightly drafted, different grammatically, which has or is capable of having
Yes.
effect. So the present tense is used. So
Hang on a
there is actually, to be fair to my lord's observations, there is actually a change, and I apologise for not drawing it to your lordship's attention straight away. It's not, whereas it was has effect, it's now having or capable of having. Not sure anything greatly turns on that, but the language of has effect was certainly in its original iteration such as to give rise to the pedantry problem that my Lord Justice Underhill just pointed out, because that wouldn't cover a scheme that was yet to have effect.
Does it? Another possible explanation might be, and this wouldn't obviously be a conventional pension scheme, but a scheme which is not primarily directed at what we conventionally think of as pensions, but which in certain circumstances might pay out benefits of that kind, but might never, because the circumstance question might never. I find it difficult straight away to think of examples, but this is a very broad definition, and you might well have some sort of insurance scheme which had, in certain limited circumstances, which might or might not arise, the possibility of providing what the Act would define as pensions. And that might be what it was intended to cover.
That's possibly, maybe if one postulates the example of a permanent health type scheme.
Yes.
We're not talking about a health related benefit, but a benefit that arises if a person has to give up their job as a result of a continuing health condition. That's not quite our Regulation 12, but it's not an completely unusual form of employment protection offered contractually. Then I suppose my Lord's point is right, that there might be a question about whether a scheme like that,
A scheme which, to put it more broadly, a scheme which in certain circumstances pays pensions, but the circumstances of a character won't automatically arise.
quite in a way, since Eady in 2006, most schemes are carefully drafted to avoid that combination.
You're talking about a health scheme that, for instance, might cover a non-employed person, a barrister, let's say, who has to retire through ill health, which disables them from continuing. The trigger, the cause of the payment would be the ill health,
Yes.
coupled with the inability to work. And that might be regarded as on retirement.
It might be, but it would depend on the drafting of the scheme. But for example, if it were a condition of the scheme that it was that the barrister should not return to practice even if his health might improve, for example, then one could see that one might say that the
I
payment.
think your overarching submission is that these three things that are coupled with on have to be triggers,
Quite so, it's not really on the event of, but
not just
because of.
if it happens to occur at the same time.
Quite so, on the
Because that
basis
could
of.
be true of a vast range of schemes.
I apologise.
That would be true of a vast range of schemes. They might provide benefits that have nothing to do with retirement age or termination of service. They might just happen to coincide.
Well, quite, and in a way, my learned friend's submission takes the risk of being, if I may say so, recklessly over-inclusive. Because just give your lordships two very practical and sedate examples. A contract of employment with a pay in lieu of notice clause, which is triggered on termination. And obviously the point of the contract of employment is to pay wages in return for the employee's work, or salary as the case may be. But in some circumstances, it might provide benefits on retirement or on termination. It's obviously not a pension scheme, one can see that straight away. The question is, can you tell in advance what the scheme or arrangement is going to do? You should be able to tell in advance. It's not a mere happenstance definition. Might there be a possible circumstance in which the contractual arrangement does pay out on termination, on retirement, or reaching a certain age? But is that the basis of the arrangement, that it should do so? And that's in my submission what the having effect or capable of having effect formulation is getting at.
It still has to be capable. The capability of having that effect still has to be triggered by the occurrence of on retirement.
Quite so.
Yeah.
Quite so.
And in a sense, although forensically it's desirable for you to explain what capable of having effect is intended to add to having effect, your bottom line submission is whatever it means, it's ultimately governed by the benefit occurring on one of the three specified events.
Quite so.
And that can't be affected by capable of.
They're quite similar. It's still the governing word is on. What is the trigger, if I can use that metaphor, for the payment of the benefit?
On a different but related topic, why did they remove payable, which, as my lord pointed out yesterday, would have solved all of this? Provide benefits to in respect of people payable on retirement. That would have made the causal link clearer as it was in the original one. And why have they taken it out?
First of all, I acknowledge the premise of the point. It is different. Secondly, I'm sorry not to be able to assist on why it was changed. But what was the thinking behind taking out that language of payable on?
You could say, if the draftsman really wants to be very comprehensive, payable isn't necessary. A benefit on
Retirement, yes.
on retirement is by definition a benefit to which you become entitled on retirement.
Yes, I mean, there is a case-specific answer. I'm not sure it's entirely satisfactory to the question, but in relation to the police injury benefit regulations, the entitlement to payment arises on satisfaction of the conditions. Maybe I can just explain that point in light of the particular provision so my lords can see it. Yes, thank you. If one looks at, please, at Regulation 43, which is tab 34, page 366. This is in the same injury benefit regulations as we are concerned with. Paragraph 43, payment and abbreviation of award. Subparagraph 6. Subject to the regulations, a gratuity under these regulations shall become payable as soon as the entitlement to it arises, and shall be paid forthwith in one sum, except in certain circumstances.
And that would cover Regulation 12. As soon as you become permanently disabled, and that was because of the industrial action, and you aren't a member of the police force, it becomes payable straight away.
So if you take your 12 months to make your claim, you still get 12 months benefit. Is that how it works?
The
12 months has got to be between the injury and the disablement.
quite so, my lord. It doesn't
And
matter in
there's a
that sense.
limitation period for making the claim, is there?
It's not a limitation period for making the claim, my lord. It's a limitation in respect of
Yeah, so
proximity.
between the proximity, as in a year and a day between the act and the death
Yeah.
in murder of common law.
I'm not sure there is a read across, but I see the analogy in point of chronology, if I can put it like that.
Well, I think they serve the same function. That seems to me it's a rough and ready causation criterion.
Yes, in a way, my lord. In circumstances where the disablement must be caused by the injury, the termination need not arise out of either. Can I come back, please, to the points on capable of having effect? I'm not sure if it's still alive, but there was a point taken by my learned friend about the statutory definition of pensions. It was taken based on the pensions, the original Pensions Act in 1948, which my lords have at tab 7, page 25, 24 to 25.
The point is, pension is a shorthand word. It's not a rose by any other name as a rose. It's the reverse. A pension by any other name may not be a pension. It may be a lump sum or a gratuity.
Quite so. Your lord has the point. I've got the printout if it's of any use to your lordships of the definition section from the 1948 Act, which is essentially the same as the definitions.
I'd be quite useful to have that.
Very good. Well, I'll arrange to have it.
Well, we were in fact told that it was the same, but
Quite
it's
so.
still nice to have it.
Quite so. So it's the same.
Perhaps that could be handed up at the adjournment or whatever suits.
Of course, just so that my lords have it, the equivalent definition is now at page 181, tab 20, in the Police Pensions Act 1976,
Yes.
and about halfway down, page 181, one sees the same point. Pension includes a lump sum or a gratuity. I ought to do very briefly with the cases. I'm not sure your lordships get any assistance from any of them, but can I just say, because none of them deals with this point.
Yeah.
The only one that's worth looking at, primarily for the purposes, if I may say so, of illustration, is Parlet. That tab 55, page 698. This is an unusual case. One can't help reading Lord Justice Chadwick's judgment in exasperation that it had reached the level of court of appeal.
Sorry, I haven't caught up. Which tab?
Parlet and Guppies, tab 55, please, page 698. There was a family dispute. It was a one-man scheme, if I can call it that. And the individual in question, the paterfamilias, was claiming to recover as against the company run by his sons, £2,200 by way of an unpaid instalment under the scheme, whatever it was. And the company sought to set off a costs liability that the father had run up in other proceedings. And there was a specific prohibition against set-off if the scheme was an occupational pension scheme. So my lords see that at paragraph 6 of the judgment, page 700, section 91 of the Pensions Act 1995, where a person is entitled or has an accrued right to a pension under an occupational pension scheme, no set-off can be exercised in respect of it. So if it was an occupational pension scheme, the set-off for costs didn't work, and that was what the dispute was about. Your lordships can also see over the page at 701, paragraph 15, what the scheme was. Pretty simple one in company resolutions. Subparagraph 10, that it was agreed that the present chairman, that was Mr. Parlet Senior, shall on his retirement be paid a pension. And the point one might observe by way of illustration is the capable of having effect formulation would enable one to test whether this was a pension scheme even before Mr. Parlett started to receive payments under it. There's very little, as it were, debate on the point of substance. One sees the Court of Appeal's conclusions at paragraph 27 on page 703. It's in the right-hand column against thirdly, about 10 lines down or thereabouts. All his lordship says, having recited the text.
So sorry, which paragraph did you
So
say?
I'm in paragraph 27, my lord. It starts at on the left-hand side, but it continues on to the right-hand column. And the relevant part is just the passage about halfway down paragraph 27. Thirdly, his lordship says, the arrangement must be such as to provide benefits, etc. And all he says is that requirement is plainly satisfied by the terms of this arrangement. He's obviously right about that. It didn't require any debate. And the actual argument in the case, at the foot of paragraph 27, counsel for the appellants argued that there were no benefits payable to or in respect of earners with qualifying service, because the arrangement with Mr. Parlett was not one of service in employment. And so in that context, that one moves on to the following page, paragraph 31, his lordship having dealt with the lack of any definition of qualifying service. He says at paragraph 30 at the top of the next page, all that means is service that qualifies for a benefit. And then he refers to Haywood and Lord Justice Millett's comment about it being a very wide definition. And that's when he makes the point about construe liberally and not restrictively. But his comments are directed to the question of qualifying service. I appreciate it can be read more widely, but that's the context of the issue.
Well, 33 is the critical paragraph, isn't it? The last 4 lines, the clue is in the words on his retirement. It is on his retirement.
Quite so much.
That's the point.
That is the point. And it's on his retirement, notwithstanding that his appointment was expected to continue for another 4 years, that the pension was to become payable. So the arrangement is entered into 4 years before any payment is going to be made. And it is a useful illustration because of the one-man aspect of the scheme. There aren't a whole host of participants and members of the scheme where some people are receiving payment and some people are not.
And in relation to this case, Johnson and Haywood, yes, they use the words liberally, but all of those were cases where the thing was payable on retirement anyway, and the argument was, did other factors take it outside pensions? The fact that it was redundancy, the fact that it was ill health retirement, to which the answer was no. You don't treat other things as limiting the on retirement because you treat on retirement liberally. But here we are in a situation where it has to be on retirement, you say, and therefore giving a liberal interpretation so you wouldn't let other things cut it down doesn't help.
May I respectfully adopt that observation, my lord? Perhaps I said that was perhaps the only point. There is one other point worth picking up, if I may, from Swansea and Johnson, which is tab 54, page 681. That's the decision about the severance scheme operated by the local government superannuation regulations. And if I may, and I apologise for jumping around, but just before we get into any analysis of the case, the regulation itself appears most conveniently at page 188 of 21.
So you say
188, tab 21,
Oh,
the
I
First
see.
Authorities Bundle.
I
It's just not clear from the report what the actual regulation is, whereas you get it in its original form at tab 21. If, as a result of an incapacity which is likely to be permanent, caused by the injury or disease, a person ceases to be employed in a relevant employment, he shall be entitled to an annual allowance. So the important point to take is that the incapacity must be caused by the injury or disease, and as a result of that, the person must cease to be employed. And it's the second point that features in particular in Mr. Justice Hart's judgment. And if I can ask you then to jog back to tab 54, with apologies to the paper bundle users.
Just L31 again. Where is the termination as well as the incapacity has to be a result of the injury?
If as a result of an incapacity which is likely to be permanent, ... a person ceases to be employed.
Yeah, sorry, I was trying to read it. Yes, I've got it.
Not at all, my lord. It's another example of very compressed draft.
Yeah.
And so if I can ask your lordships to come back, please, to the report at tab 54, and to see in particular the analysis in the judgment. That's bundle page 687. Well, my other friend has already shown you the passage from F to H, so I shan't repeat that. But one of the concerns his lordship identified was that there was a dispute. You see this from the bottom of 689. There was a dispute as to the reason or the basis on which the complainant's employment had ceased. The lordship identifies the point at the foot of 689. The authority was submitting that the employment had ceased as a result of redundancy. And if that was so, it could not also have ceased as a result of incapacity, as envisaged by the regulation. And there was a procedural history which one needn't concern oneself with. And his lordship then says at C, if it is possible for the employment to be regarded for the purposes of the regulations as ceasing both as a result of redundancy and as a result of relevant incapacity, there might be nothing wrong with this model, if you like. However, in my judgment, that is not the case. In other words, it had to be one or the other. And his lordship goes on to explain that there wasn't in fact any basis for the ombudsman to conclude that the reason for termination was incapacity. And the conclusory words are on page 691, just between G and H. Referring to the ombudsman, he must have been assuming that the employment had ceased both by reason of redundancy and by reason of incapacity, and moreover that the council was accepting that. And if so, and assuming that he is right and saying you can't do that, it's either one or the other, then that was an error of law by the ombudsman. And then you pick it up again, if I may, just at the end of this section on 692, between C and E, referring to the advice which the authority had received, significantly omitted to mention the critical requirement that employment should have ceased as a result of the permanent incapacity. On the evidence, therefore, the authority never applied the right text. And his logic goes on at D to E to say there was no evidence before the ombudsman from which he could independently conclude that the employment had ceased as a result of relevant incapacity. So what his lordship then did was remit it to the ombudsman for him to decide that point. But the reason for going through all of that, and perhaps I've laboured it, is that because of the particular form of that rule, that entitlement, it was important to establish that the termination had in fact occurred because of incapacity rather than redundancy. It couldn't be both. And hence, again, my point about Regulation 12, if you apply the similar sort of reasoning to Regulation 12, one has to establish that the reasons for entitlement are satisfied. Yeah. And they go well beyond the circumstances set out in Section 1.5 of the Pension Schemes Act. I'll just check my notes, if I may. what I'm not going to do, I hope your lordships will be perhaps gratified is too strong a word, is go through all the detailed points in the skeleton argument explaining the history of the legislation. One thing just to draw out, if I may, in respect of the, what I might call for short, the elective adoption of this statutory wording. In other words, there were alternatives available at the time, and it's not mere happenstance that this form of word was chosen. Can I just make sure my lords have the chronology straight? The point is that the Disability Discrimination Act 1995 was amended with effect from the 1st of October 2004 to include police officers. And at that time, the Injury Benefit Regulations 1987 had been in place for some years. That's Regulation 4. From my Lord's note, it's page 206, tab 23, 206. That's the predecessor of our current Regulation 12. That was in place from 1987. So in situ for some years before the inclusion of police officers in the protection of the disability discrimination.
And just explain why we should find that so exciting.
Well, perhaps I shan't rise to the ambition of excitement, my lord, but let me see if I can just explain the next stage in the point. On the just before that amendment to the Disability Discrimination Act, on the 22nd of July 2004, Section 150 of the Finance Act 2004 was enacted. And my lords can see that at tab 29. 246 gives your lordships the date. On the following page, 247, it's a more recent version that's in the bundle, but this was introduced in July 2004. And one sees a wider definition of pension scheme, and this is for tax purposes, of course, so aren't necessarily the same, but it includes on death or on onset of serious ill health or incapacity, or in similar circumstances.
Does it go any further than saying Parliament could have used different words if they meant something different? And look, hey presto, when they're doing tax, they do use different words.
Well,
Is that it?
the only additional point, my lord, is that it's all very proximate in point of time. And so there is a better inference that one form of words was chosen rather than another, rather than it merely being mere happenstance.
If you actually want to know whether historically it was, that would be a big leap. You don't know whether the drafting team responsible for the amendments to the 95 Act were the same drafting team as responsible for the Finance Act. I thought probably not, but you don't know. I can't believe your general point. There are other words in the statutory armoury is a good point as far as it goes. I'm not sure you add very much to it by saying, and in fact they were used in statutes only a few months apart.
I acknowledge the point, my lord, in the sense that the inference depends on perhaps who was responsible. It may be entirely different streams of thought. My point is that they were...
And the people were struggling with taking those words in Section 1 of an earlier act and saying, now, which words can we strip out? Which words can we strip in? They were engaged on different... One was trying to get money out of people for tax, and the other was trying to sort out pensions.
well, maybe, my lord. I think in the context of this particular definition, it was to distinguish between schemes that were approved for tax purposes and schemes that were unapproved for tax purposes. So maybe not, but I take my lord's general point. Purposes,
but we just don't know is the short answer. We can't speculate.
I think this is a tiny finial of icing on the cake. It's not really your best point or your main point.
Very good,
necessary to your point.
All I would conclude on this point is by saying that when the Equality Act used the definition from the Pension Schemes Act for an occupational pension scheme, and it's really the same point, it could have used a different definition if it had wanted to. It could have taken the Finance Act definition if that had been the intent. The brief point to make, just so that there isn't any lingering sense of doubt about it, about the substantive tax position, I can ask my lords to turn back to tab 28 and page 238. section 393B. And I acknowledge straight away that this court will not want to journey too far into the heart of the text point, but all I wanted to observe in response to my learned friend's submissions is that it isn't necessarily so clear that a payment under the Regulation 12 would be tax-free, if my learned friend is right about its interpretation, because of the wording of subsection 3A. It has to be a benefit in respect of ill health or disablement of an employee during service. And if the circumstances were such that the disablement or the ill health, the substantive ill health or the disablement which entitled the person to the benefit under Regulation 12 arose after service rather than during it, then it could be a problem for the tax treatment of the payment. That's all I wanted to flag, my lords, that it wasn't drafted in such a way as to deal with the sort of case that is presented by these two fact patterns. So I'm going to conclude, my lords, with just some observations on Regulation 12, if I may, and ask my lords to turn to that in the bundle. It's tab 34, page 317.
Tab 44.
334, 34. Apologies, my lord.
Which page?
317.
Oh, of course, Reg 12. Sorry.
Reg 12.
Don't need to be told the page.
There's so many numbers in this case, it's
Black.
not easy to
No,
remember.
no, it's fine.
So I've got in my list 9 points, but they're all brief. The first is that the nature of the benefit is expressly described as a gratuity. See subparagraph 2. And that is not mere chance. This benefit operates on a non-fault and a non-contributory basis. So in other words, the officer in question doesn't have to show that his employer or her employer was in any way responsible for the injury or the disablement, nor is there any payment made in respect of, by the individual officer, in respect of the entitlement. And indeed, the officer doesn't have to be a member of the police pension scheme in order to benefit. It might be a surprising decision to opt out from a scheme of that kind, but people do sometimes do. Second point, the rules do not involve what might be described as any discretion on the part of the relevant police authority. There are some evaluations required, so in other words, without his own default, in subparagraph 1A, in the execution of his duty, also that paragraph, and totally and permanently disabled as a result of the injury, subparagraph C. But if they're satisfied, it's a matter of right that the individual receives the payment. There are additional provisions about default, execution of duty, and so forth, which I'm having trouble about. The third point, and I've shown my lords this already, Regulation 43 on page 366, the gratuity is payable as soon as the entitlement arises. I mention that only in this context because my learned friend argued yesterday that the language of the provision of benefits in section 1.5 of the PSA was a looser form of words than an entitlement to benefits. But in my submission on this regulation, it's a distinction without a difference. Third, the fourth point, I'm sure my lords have this already, the disablement, total and permanent, must result from the injury, but the termination need not result from the injury, nor from the disablement. That's a general point. And point 5, a more specific iteration of it, is that termination might arise for a completely independent reason, such as misconduct. But Regulation 12 would still be capable of application if the criteria were otherwise met. And I'm not suggesting for a moment that either of these appellants is in that territory. I don't want to give that impression. All I mean to convey is that it emphasises, if you like, the welfare nature of the payment rather than the compensatory aspect of the payment. It's about what the individual needs as a result of their injury and total and permanent disablement.
It's a partial help to them because they get 5 years of salary, given that they are totally disabled, which means they can't perform any work at all. That's the definition.
And earn any money in any employment.
In any employment, yeah.
So, the next point to show, my lord, point 6, is the forfeiture provision. And that's at page 362.
Sorry, I had the fourth point being termination need not result from the injury.
Point 5 is termination might arise for an independent reason. Such
Oh, I
as
see.
conduct.
Sorry, I thought that's.
I mean, yes, I
already the same.
apologise, my lord.
Yeah, okay, got it. No, 6.
6 is forfeiture. For that, you need please page 362, regulation 40. And the very simple point is the forfeiture rule doesn't apply to the regulation 12 payment. It applies to regulation 11, which my lords have seen in passing, as it were, 13 and 20, which are adult survivors and adult dependents payments. But they don't apply to the regulation 12 payment. Back to 317, if I may.
How do we know that, sorry?
Say again, my
Oh,
lord.
because it says it in the beginning of 40, subsection 1. Yeah, okay.
Oh,
Sorry,
yes,
go-
because it doesn't say regulation 12. It
I just hadn't seen the words. Yeah, I got it. Yeah.
apologise, my lord, I'm taking it too quickly.
Yeah.
So, back to 317, if I may, in regulation 12. And I invite my lords to ask the question, what gives rise to the entitlement under regulation 12? My submission is it's the accumulative effect of 1A to C. None of those matters on its own. And certainly not B on its own. Next point, number 8 on my list. I submit that the key limiting factor, given its, as it were, most unique aspect, is the total and permanent disability as a result of the injury. In other words, that is what is limiting the application of this rule to the most serious cases, as my Lord Justice Lewis just pointed out, the inability to earn any money in any employment. That's regulation 7, subparagraph 6 on page 308. And if I can just ask my lords to go there, not to look at that point because it's straightforward, but for the final point on this. The focus in regulation 7, subparagraph 5 explains where it is necessary to determine the degree of a person's disablement. It shall be determined by reference to the degree to which his earning capacity has been affected as a result of an injury. And there's a deeming provision in respect of total disability. And the point which my lords will have got already is that it's effect on earning capacity rather than on earnings. And it emphasises again, if I may say so, the welfareist nature of this provision rather than compensatory in particular. There's an assumption of what the compensation ought to be, as my lord has pointed out already. 5 years' money in essence as a maximum. So really, just by way of conclusion, and I appreciate this is subject to the EU law argument, which is going to be addressed by my learned friend, Mr. Lockwood. What I say is that this is not an obvious claim for litigation in the Employment Tribunal, because the challenge is to the very structure of Regulation 12. And what would happen, as it were, is a matter for speculation, but essentially it's an attempt to strike down the 12-month rule. And one has to ask oneself, well, what would happen in that scenario? How is an employment tribunal well placed to judge what should go in place of the 12
Well, they
month
don't. All they do is they ask, does this put non-disabled people at a disadvantage, at a particular disadvantage? If so, is it justified? It's what they do every day of the week. And then if they strike it down, then you leave it to the Secretary of State and he decide, well, shall I take away the 12-month rule or can I justify another rule? That's That's what they're there for.
No, I follow, my lord. It's just that the question of the attack on the 12-month rule is, in light of the jurisdictional question before, my lord, invites the question of, leaving aside the EU law point, where would be the most suitable forum for a challenge of this kind?
It wouldn't be judicial review, as you suggest. I mean, you need to know, for example, lots of factual things, and you don't normally do those on judicial review.
Well, assuming there were a factual dispute about the reasons for the rule.
No, the question whether it put somebody at a particular disadvantage, you'd want evidence of that.
Well, as I understand it, my lord, the comparison in this case, I don't want to get too far into this because I appreciate it may not assist my lords terribly, is between different types of disabled people rather than between a disabled person and a non-disabled person. Because the very premise of the operation of Regulation 12 is that the individual will necessarily...
Yeah, well, this is one of your substantive points.
Is it unsuitable for an employment tribunal? Is it something that you'd be shocked to show in front of an employment tribunal?
Well, perhaps shocking is putting it too high, my lord, but perhaps an employment tribunal is not particularly well equipped to grapple with issues of this kind.
But does let us assume the employment tribunal has jurisdiction over Section 61 disputes. Won't that inevitably mean that Parliament sometimes intended it to decide on the effectiveness, on the validity of a rule and the justification for a rule? That's just built into the fact it has jurisdiction in such cases. Why is that? What's special about the issue in this case that means that it's not particularly suitable any more than any Section 61 claim will be, on your view, unsuitable?
All I say is special about it, my lord, is because it's about the structure of the statutory provision and what we're focusing on, the 12-month rule. It's not about some application in a particular way of a rule to a particular person. In other words, to say that the rule applies in a way that is alleged to be discriminatory.
But you will often get provisions of an occupational pension scheme which are inherently discriminatory. In this particular case, it happens to be the 12-month rule for this particular kind of benefit. But wouldn't the same objection be raised to that? That such and such a provision indirectly discriminates against women.
Different rates for part-timers, most of whom will be women.
And you could certainly challenge that by way of judicial review. But you could have no objection if an individual affected by it decided to bring it as a claim in the employment tribunal, could you? I suspect, and I can't cast my mind back to some of the discriminatory pension scheme litigation that's occurred, but I'm pretty sure probably some of it is judicial review and some of it is individual cases. Perhaps my lord's memory is better.
Well, Neath, which I was in, was employment tribunal. Seymour Smith, which wasn't pensions, but was qualifying thing, was judicial review. It depends whether it's brought by the Equal Opportunities Commission, whether it's brought by an individual, but it could be in both. And there were cases of both.
Yes, if I may say so, I don't want my lords to get the impression I'm saying that it could not possibly be determined in an employment tribunal. My submission is that it's not a shocking conclusion, if I can use the same adjective, to say that it shouldn't be determined in an employment tribunal. It should be determined in a different...
In a sense, it doesn't matter if Parliament's decided whether I'm shocked or not. It doesn't really matter. Parliament does lots of things that shock me, but there it is.
Yes, I understand, my lord. The shocking test is not the criterion. But all I mean to say, really, is it's a fairly limited point, but there is a point nonetheless. That this is not preeminently a matter for the employment tribunal to the exclusion of any other forum, and that therefore it is not a...
But that would be a better point to take, wouldn't it, if effectively conceded, but probably inevitably conceded, that the case falls in the ratio of P and of Eckland. Why am I missing something?
Because the premise of that, my lord, is the intervention of EU law into the debate and
Yes.
the operation of the autonomous concept in respect of pay. And once one's into that territory, it's no longer.
No,
it's
sorry,
longer-
it's a bad point on my part.
Well, it's not a bad point, my lord, but it's just that explains why that premise of Eckland.
Could it be brought by a Part 8 claim in the County Court or the High Court? Or a Part 7 claim?
In my submission, my lord, I can't see why not. It would be an application, a claim for a declaration
Yes.
that the rule was unlawful.
That might be on the
Because-
basis, might be more thought to be more appropriate on the basis that it might involve elaborate factual inquiry. On the other hand, one does know that in judicial review cases, from time to time, elaborate factual inquiry is undertaken, especially when it doesn't actually involve.
And the Secretary of
Cross-examining
State might
witnesses.
argue that a Part 8 claim was an abusive attempt to bypass the restrictions on judicial review, timetabling and so forth.
It's possible, my lord. I wouldn't want to give, as it were, any binding commitment one way or another as I stand here. But it would be.
Fine, because I've recently had a case in which that very point was made.
I follow. I thought your lordship was going to say that the Secretary of State might take a point that there was a matter for the Employment Tribunal. But having made the submission to your lordships, I would have rebuffed that suggestion, because obviously it would be an improper point to take in those circumstances. But
Well, there we are. We spend a lot of time on this point. We see what you say on it. Yeah.
I'm very grateful, my lord. So all I say is that the first ground should be dismissed. Regulation 12 is not an occupational pension scheme and shouldn't be treated as one for the purposes of Section 61.
Yes. Thank you very much indeed,
Grateful, my lord.
Ms. Hodgetts.
My lords, as you've heard, I'm going to address you on ground 3. And the starting point is, while your lordships have said that you will hear it de bene esse, the premise of our objections. My lords, can I ask you please to look in the core bundle at page 188 for the cross appeal. From the judgment of the Employment Tribunal to the EAT. Because of course the ET had upheld the jurisdictional point on the section 61 point
Yes.
and dismissed it on the section 108 point. And so we see, my lords, at page 188 at the bottom, the respondent's cross appeal. And what
So
is
very
said,
strictly speaking, it wouldn't be a cross appeal, but people always get muddled about that. Don't they?
indeed, and paras 8 and 9 in particular, it's brought to protect the position. If the EAT should uphold the appellant's appeals, in that event, the EAT will be invited to consider whether it falls within section 108 instead. And 9, it follows that the respondents do not put forward at this stage any grounds upon which it said that the conclusion was an error of law. And then, my lords, consistently, it might be thought with that, that is not advancing any positive case. At page 15 of the permission bundle, which
Just hang on 1 second.
Yep.
And sorry, in case Mr. Feeney is smarting at what I said about it not being a cross appeal. Given the way that the judgment formulated, I see actually made effectively a declaration that it didn't have jurisdiction under section 108. You might think that you are actually appealing against that. So
Yes.
yeah, sorry, I was over hasty to say it wasn't a cross appeal.
Indeed. My lords, I've taken you to page 15 of the appeal bundle for the relevant paragraphs of my learned friend Mr. Feeney's skeleton argument before the EAT.
Yes.
And my lords, those paragraphs are, perhaps unusually it might be thought, repeated in the judgment of Mrs. Justice Eady, and that's in the core bundle at page 75.
second. I'm just making a note. Yep, sorry, yes, EAT.
Page 75 of the core bundle, my lord.
Yes.
Now, to be clear, of course, this is the part of the judgment dealing with the parties' submissions, not Mrs. Justice Easy's own analysis. But nevertheless, it is striking that she thinks fit to copy into her judgment what is said on this point. And then it is in that context, my lords, that at pages 88 to 89, she records, in addition, what was already said. My lord, you've been taken to the final sentence of page 88 and paragraph 100 on page 89. And my lords, if there is prejudice, the prejudice is this, that we have come before your lordships without this problem, without this issue having been fully aired on the part of the appellants. And if I may
Sorry, can I just be clear? I understand what you mean by that. Without it having been properly aired below, or do you mean even aired for the purpose of this appeal?
Two aspects, my lord. It wasn't aired in the Employment Appeal Tribunal to any real extent. What you see in the judgment fairly records
I see that.
what was put before Mrs. Justice Eady. But the second point, my lord, and it partly derives from this, one suspects, is that you've heard my learned friend Miss Monaghan, KC, say that section 108(1)(a) isn't in dispute.
Mm-hmm.
Now, my lords, it's right to start with the pleadings in relation to this, because it is entirely proper to point out that in the pleadings, a positive case wasn't advanced by the respondents in relation to section 108(1)(a). So may I refer you, please, to the core bundle at page 307 for the first claimant. And this is the Secretary of State's plea.
I missed the page. Can you give me
My
the
lord, page 307.
Thank you.
So that's the grounds of resistance of the Secretary of State.
Indeed, my lord, for the first claimant. And then in relation to the second...
Sorry, no, hold on, I'm not clear. This document that you've just shown us is the Secretary of State's document, is it?
It is, my
That's
lord.
his response now to the claim.
Yes.
And you want us to look at page 307?
307, paragraph 13. And
Yes, I see. I'm afraid I haven't picked up that. Well, 108 wasn't originally relied on in the grounds of claim.
Quite so, my lord. And the same point applies to the second claimant's amended grounds of resistance as well. There's no need to take you to it.
Yes, no, fine.
It isn't advanced. But my lords, you will have picked up that this case has had something of an organic quality about it, not least the EU law point has developed over time. And my lords, by the time we in fact...
I'm a bit lost now, I really am so sorry. So it wasn't in the original document that formed the grounds of claim, but there was an amendment before the Employment Tribunal hearing in which they did say 108, and then you replied in your amended grounds.
No, my lord, I'm showing you the final version of the amended grounds of resistance.
I see that, but I think both my lord and I are puzzled. Surely it implies from this that because this is itself an amendment, that the original round of pleadings, they had not relied on 108. No? As to the amendment, paragraph 13 starts, as to the amendment at 52 of the GOC, the Employment Tribunal does not have jurisdiction to hear a complaint under Section 108. The natural, though perhaps not inevitable influence from that is they hadn't relied on 108 first time round. It may not matter very much, it may be only a debating point, but it's quite useful to get it right.
Yes.
Do we presumably have the original, we have the amended grounds of claim.
My lord, cross-referring,
And the 231, and they seem to have added 108.
yes,
231. So it wasn't there originally, but it was in the amended ground, and then you replied to the amended ground.
yes,
Yeah.
yes, my lord, you're ahead of me. That
Okay,
is-
well, I'm not sure it goes anywhere, but at least we can, as I say, you can make a sort of debating point that they weren't even sure about 108 at the very beginning of their claim, but still,
Quite so.
it was before the ET.
Well, this is the final form of the amended
Yes.
grounds of resistance, so it wasn't pleaded, but by the time we got to the ET, it was an issue, and I can demonstrate.
So, well, what is page 231 then? I thought they put it into the pleadings of 231. I mean, in line 4 of paragraph 52, the numbers 108 are added.
Yes, that's correct.
Yeah.
And this is before you get to the hearing.
Yes, it is.
Yeah.
Yes.
Yes. But turning, my lords, to the.
Well, sorry, I just want to be clear, because we asked you questions about it, we didn't actually look at what is said in para 13. Perhaps you're coming back to it. But someone, probably you, pleaded claimant and the second respondent were not in a relevant relationship at any time. That's the Secretary of State. Well, yes. But what about the Chief Constable? So
It's apologies, my lord. It's C of paragraph 13. That's the salient point.
Right. Well, that's wrong, but yeah, okay, yeah.
just let me just read the But it doesn't look there as though you were taking a point on B, on A, or not explicitly. You were putting it squarely on B, as it were, on behalf of the Chief Constable.
Yes, on behalf of the Secretary of State.
I understand that, but your primary point is there may be a relationship with the Chief Constable, but there isn't with me.
Yes.
And
Yes.
I have no idea. That's, I guess it's into section 111
Yes.
territory, and I don't.
But focusing on subparagraph C there, the point is we don't advance a positive case in relation to 108(1)(a). Having said that, my lords, when we turn to the ET judgment,
Yeah.
as you will see, the matter is fully aired, both on the basis of A and on the basis of B, page 196 of the core bundle.
Page which, sorry?
196, my lords. of the core
196,
bundle.
yes, thank you.
My lords, you will see it really starts at the bottom of 195. Both counsel and the respondents submit that there was no close connection and no causative nexus between the conduct relied upon and events in the previous relationship going beyond a but-for connection. And then the learned judge found it seems to me on the facts the refusal to pay gratuities under Regulation 12 arose out of the relationship between the first respondents exercising his duties under the regulations and the claimant seeking benefit thereunder. In other words, not out of an employment relationship, a different type of relationship. So you will see that there the learned judge makes an express finding on that point, and then explicitly, clearly echoing the language of 108(1)(a), and then explicitly both respondents are adopting the reasoning of the ET in the case of Curry, and that deals with the 108.
So that's the B point.
That's
yeah.
the B point. And then para 12, I respectfully adopt the reasoning of Eady J Buchanan both in relation to 1A and 1B.
Yes, I see. So just being formal about it, although you're pleading, it may actually be that if we looked at the Chief Constable's pleading, they took a different approach. But even your pleading didn't take a point explicitly on A. It was certainly live in front of the tribunal, so any pleading point is dead.
Indeed, my lord.
Yeah, okay.
It was therefore live before the ET. My learned friend Mr. Lockley and I both dealt with it in skeletons. You've seen what happened at the EAT.
Now I see the time. I mean, if you're just finishing a sequence, let's just go on and we'll. But look for a convenient time to break.
I will do, my lord.
Yeah.
Simply to conclude the point by saying we're here and we don't know what the claimants, the appellants, I beg your pardon, are going to say on section 108(1)(a). That's
Don't you? Because I see on 108(1)(a) because Ms. Monaghan didn't treat it as an issue, and therefore has made no submissions about it.
coupled, my lords, with the fact that it wasn't aired. The appellants would have had to have appealed against both findings of the ET, that is both on section 108(1)(a) and 108(1)(b). Now, I don't want to put this too high. Clearly, we can anticipate what they're going to say on section 108(1)(a). But the position is it hasn't been canvassed in the AT below.
Can I just be clear what you're saying? Because of the history, you don't know what their case is on one. You didn't know coming into this appeal, I mean, into this hearing, into this appeal, what their case is on 108(1)(a. I would have to reread the skeleton, but didn't it become clear at the skeleton what their case was?
Well, in the EAT skeleton.
No, I mean the skeleton here. Why don't we rise now? But because I just want to make clear, want you to make clear after the adjournment exactly what you're making of this history. You've made the point very clearly and effectively how it was developed, but the real question is, how are you prejudiced in now arguing a point of law which was not argued at all in the EAT?
Yes, it's a simple point, my lord. The 108(1)(a) point isn't dealt with at all.
But does that matter? We can deal with it.
My lord, we can, and I don't want to overstate the position. Yes. I simply make the point on the permission application.
Fine. Mr. Lockley, were you getting up to say something?
I was getting up to a few copies of the tune-in case.
Oh, that would be very helpful.
Would it be helpful to have those before the adjournment? I've got them for one and all. I'm just showing them one that I've marked up on the front, just the paragraphs where one finds the depart from.
Thank you. We're not.
I wasn't going to suggest he was sending secret notes to you, but thank you very much.
Thank you very much. As you can see, in a typeface without serifs, it could be Tunhelm.
That's my fault. I was getting all
Appalling grammatical fonting. Can't do it.